Good morning and welcome to the ISQ webinar, Enrolments, Contracts and Management. My name is Judy Young and I would like to welcome today as our guest presenter, Mr. Robert Cunningham. Robert is Special Counsel at Paxton Hall Lawyers. He's the person who's advised ISQ in the drafting of the school enrolment contract template that many of your schools currently use. Today's presentation will commence with Robert giving information about the enrolment contract and the rights and responsibilities under that contract. He will then respond to the questions that you have sent in. Amazingly, we've received 15 questions about this important school contract. It's obviously an area that is of high importance to schools. I'll hand you over to Robert now for him to start his presentation.
I thought we might start just by having a quick look at the matrix of legal obligations for schools. So the schools are covered by statutes, the duty of care and contract. There's more and more statutory regulation of schools and the activities within schools. Dealing with things like child protection, privacy has become a big one over the past couple of years, discrimination, accreditation and even credit control these days are things that affect the schools through statute. So if a statute says you've got to do something, then you've got to do it. There's no argument about that. It gets a bit looser in the areas of duty of care and contract, as we'll see during the course of this discussion today. So the second area is the duty of care, with which I think schools are very familiar because there's been so much action and activity around this area, the duty of care that we owe to students, but also anybody who comes into proximity with the school, usually physical proximity. We have an obligation to take care of them. And of course, we always have to act in the best interests of the student. And the third area is the area that we're going to concentrate on today, which is the area of contract. The area of contract is the area that governs the legal relationship between the school and the parents, essentially. The relationship that the school has with students, apropos the enrolment contract. And the first one is that until a child reaches the age of 18 years, it's very difficult to enter into contracts with them. We'll say a little bit more about that later in answer to one of the questions which has come up. But the law in Queensland is that a contract with a child, a person under the age of 18 years, is unenforceable against the child unless it's a contract for necessities. But defining what necessities are is very difficult, and it's not recommended that people enter into contracts with minors unless they absolutely have to, but we'll deal with that a bit more a bit later. The second very important aspect of this is one which I think most schools will be familiar with, which is the extent to which a school should take into account the wishes of a child. When I say child, it's anyone under the age of 18 years. Different children develop at different stages, and the need to consult them will depend on the level of their maturity, the nature of the decision to be made, the relationship with the parents and so on. So it's a very subjective thing. But essentially, as the child grows and matures while they're in your school, you'll need to take more and more heed of them until in grade 12, some of them will be quite capable of making decisions for themselves. And the third thing is, as I adverted to previously, it's always very important and probably of most importance to act in the best interest of the child. So when you get embroiled in statutory obligations and contractual obligations and obligations relating to duty of care, if all else fails, just think what is in the best interest of the student, do that, and it's most unlikely that you're ever going to be punished by a court or anybody else if you do that successfully. So I thought it might be useful just to explain to you what the legal experience is with claims being made against schools in the three different areas. First of all, the statutes tend to set up rights for people to have a go at organisations which are perceived to be large and which may otherwise take advantage of consumers. So we have credit control legislation, We have legislation relating to discrimination, and it's open and it's facilitated by the legislation for people to take action under those statutes. They can do so cheaply because often legal representation won't even be allowed. Also, matters might, under the statute, have to go to mediation or even arbitration or conciliation before they get to court. So we have to go through all those procedures. There are lots of these claims being made. Most of them are being disposed of without going to the formality of court. They're usually resolved beforehand. And often the reason that they're resolved above all else is that they cause enormous inconvenience to the schools and can be quite expensive as well. So it's best to avoid getting into a situation where somebody is making a claim against you under the statute, and if they do, take a realistic and practical approach to whether you should settle a claim or not. The second area, the duty of care, will have been lots and lots of cases suing schools for personal injury actions, particularly in the areas of sexual abuse. Bullying's becoming a bit of a favourite. Just the normal old-fashioned accident. People like to have a go at the schools if they possibly can. And the reason that you see lots of claims in this area is that the amount of compensation which is potentially available is very high. So if a child is maimed for life, then the cost and damage to that child is significant, and it makes it worthwhile for the child, the parents, and rapacious law firms to have a go at schools if they possibly can. Often these claims are going to be met by insurers, so they don't necessarily involve huge amounts of time for the school, but the insurers and their legal advisors are going to require the schools to do lots of work, provide documentation and so on. So once again, it's best to avoid getting into a position where somebody's making a claim, but again, it's an area where there are many claims. In contrast to those first two areas, there are very few claims being made in Australia against schools. There is a trend in Australia for people to sue tertiary institutions for failure to provide education services of a standard which has been represented to the student before they enrolled at the school. So if somebody says you'll come out with a certificate 4 in cooking or something like that, and they come out with a certificate 5, they're more inclined to have a go at the tertiary institutions. To some extent, this reflects the trend in the home of all litigation, which is the United States, and you can expect that in the future there will be more rather than less of this kind of litigation. So as far as the enrolment contract's concerned, and the surrounding enrolment process, you should make sure as much as you can that you don't over-egg the cake. You don't tell them things which you can't possibly achieve for their child, and you should also, to the extent that it's reasonably practical, keep reasonable records of things that are said and given to the parents in marketing material. So the enrolment contract can be a very powerful tool, both as a mechanism of defence, it reduces the risk of claims, and also as an offensive weapon, which is essential in debt collection. So let's have a look at the defence first. Here are some examples of areas where the enrolment contract, if it's properly prepared, can be very useful indeed. Now the first one, this gives you an indication of the care which you must take when you're actually preparing these enrolment contracts. The ISQ standard form recommended says that we'll provide education services with due care and skill. Now those words are words of magic because they're actually in the consumer guarantees. So what we're doing is we're saying we'll comply with the consumer guarantees and we're not going to promise anything more than that. But by the same token, as a marketing weapon, it's useful to say that, yeah, we'll agree to do it with due care and skill, and hope that, that they don't require a standard which is much higher than that. But if you put words in there that are different from the consumer guarantee, then you stand the risk that not only would you be liable to the standard of the consumer guarantee, but you will also be liable for the extra words that you've cleverly inserted in there in an attempt to be nice and kind and sound really terrific when you're enrolling people. The second example that I have there is disability assessment. It's very important that you have full knowledge of a child's disability before the child is accepted for enrolment at the school. It's much easier to deal with the assessment of resources required, and it's much easier to exclude a child from the school before they're enrolled than it is after they're enrolled. So the enrolment process, not just the enrolment contract, but the whole enrolment process must have mechanisms in it where the parents are required to disclose to you any disabilities or learning difficulties that the child has so that you can make your assessments. Not that we want to exclude people, but we have to have the proper opportunity to work out what resources are required in the best interest of the child. Again, but the enrolment contract itself, the ISQ standard form, which I'm plugging for you today, Judy, contains a warranty by the parents that they have disclosed all that information and that they will continue to disclose information as it occurs during the child's schooling. Bear in mind that these contracts can stay in place for 12 years from grade 1 to 12 while the child is at the school, and commonly do, and anything can happen to the child in that interim period. So it's very important legally to have the parents tied up, not so much with a view to suing them if something goes wrong, but having a piece of paper in your hand where you can say, now look, when you enrol this child, you warranted that you'd given us all the information. You clearly haven't. You've concealed some of it actively, and that puts you on the front foot in any negotiations that you're having with the parents. And it's also relevant to the Discrimination Commission as well when they're making any assessment of a complaint. The third example that I've got there for the defensive role is communication. It's really important practically from the school's point of view that you can communicate important information and legal information to the parents by the most practical means available, which these days is by email and also by the school website. So if the enrolment contract is properly drafted, it will have an agreement by the parents that they will accept communication in that manner unless they inform the school that they want something else. So the default position is that you can send out emails to them and communicate with them in that way. If they want something else and it's reasonable for them to ask for it, then they can do so. We don't always have to be on the defensive, you know, in the schools. We can go on the offence occasionally. So here are some ways in which you can pursue these people. So the first point to understand about the enrolment contract is that, as in the ISQ standard form contract and in any enrolment contract that's properly drafted, it will provide that the parents, that is the people, I'll refer to parents as the people who are actually signing the enrolment contract. Not always parents, as we know, but let's just use that term for the moment. If two parents sign the contract, then they're jointly and severally liable. That means that each of them is liable for the full amount of any money that's payable under the contract. The school can pursue either one of them. It's very common for one parent to come in and say, well, we've agreed that he's going to be responsible for the fees or she's going to be responsible for the fees, so you'll have to go and get it from them. It's very useful to, at that point, pull out from the drawer the enrolment contract and say you're jointly and severally liable and you better pay up. So both parties are going to be liable until the contract is terminated. Sometimes they think they can come in and say, well, as from next week, I'm not going to be responsible for the fees for the student and my partner here is going to take full responsibility for them. Once again, you can politely say to them, I'm sorry, but you're both going to be liable until the contract is terminated. And often that requires a full term's notice. So they're both going to be liable for quite some time. In the enrolment contract, if properly drafted, you can put a limited time for payment, which might be 7 or 14 days. It might even be before the term has commenced, because From a debt collection point of view, a cash flow basis, you're going to want to know pretty early if there's going to be a problem with the payment of fees, so that you can take whatever action is suggested in the circumstances to recover it or to allow for it. The fourth one there is that the school can increase fees. So if these contracts are going to remain in place for, say, 12 years, then obviously the school is going to need a legal right, to be able to increase the fees and recover the increased amount from the parents. You have to be careful in your drafting in this area because of the unfair contract terms provisions of the Australian consumer law, because if one party has a right to vary the price of goods or services under a contract, then it stands to be avoided as an unfair contract term unless it's drafted in the right way. So you'll find, for example, that the ISQ contract has been cleverly drafted so that it provides that if you increase the fees by more than a certain percentage in any year, the parents have the right to terminate the contract. And that's generally considered to be a fair way to do it. Of course, you can put on top of that that they can only terminate within a limited period, which tends to restrict their right. And it gives you more certainty as to whether they're going to be lining up for the next year or not. So once again, you need to be careful with the drafting. The one terms notice thing is a bit of an issue. It comes into the area of contract which deals with liquidated damages and penalties. Sometimes those clauses are not enforceable. The provision about a clear terms notice or fees in lieu of the notice has been around for a very long time in the independent schools. And as far as I know, it's never actually been tested by anybody in a court. I'm inclined to think that it would probably be okay, but it depends on arguments from the school that they determine the level of resources they'll require and make commitments on the basis of enrolment. So if people suddenly pull out, it can leave the school in a position where it's unable to reduce its expenditure. I mentioned communication before as an important point to be taken up in the enrolment contract. You're required under the education legislation, both Commonwealth and state, to report to the natural parents of a child, actually to the people who have responsibility for the child. We'll talk about this a little bit more later because there's probably, family law is one of the areas which causes schools most angst and inconvenience, so we'll deal with that in relation to some of the questions. But you must also report to the contracting parties, so the people who actually sign the contract. We have an implied obligation to report to them on the progress of the student at the school. The schools are not usually subject to family court orders. In fact, I've never seen a family court order which directs a school to do or not to do something. There are fairly obvious reasons why the family court isn't going to do that. Essentially, the court is concerned in the battle between the parents who have separated and who are intending to divorce, so they're talking about property settlement, and then parenting orders for the children. The principles under the Family Law Act are that the natural parents of the child have responsibility for the child to the exclusion of all others, and they retain those responsibilities until the child reaches a level of maturity that no longer warrants it, or unless the family court expressly makes an order removing the responsibilities in whole or in part. So it's as simple as that. The natural parents are the ones who have the responsibility for the child, and we have obligations to report to the natural parents on the progress of the child. If you get into situations where the parents are arguing about fees or some direction to the school as to what's to happen to the student, what I suggest you do, usually these things can be worked out informally. I think the school should say to them, well, listen to both of you. This is what we're proposing to do. And if one or other of you doesn't like this, you can either go away and sort it out between yourselves, or you can go and get a family court order to sort it out between the two of you. But this is what we suggest should be the course of action. But don't get involved in the family court side of things.
Now, Robert, as you're aware, we've asked our participants for this webinar to send in questions. And as I indicated in the introduction, we've had 15 questions come in. What we've done is group many of them together. So the 15 relate around particular issues with respect to the enrolment contract. What we'll do, if you're okay with that, is to go through each of the questions one by one. I won't read them. Obviously the participants are able to read the questions themselves, but what I might do is just summarise them and the sorts of aspects of the enrolment contract that it's relating to, and then ask you for your comments on it. So let's start. Question 1. It's around it's a vexing question around the change of name of a student. In this instance, the surname, and whether the contract is still valid.
Okay, I might just preface my answers to these questions by saying that what I say is going to be the strict legal position. But I fully recognise and appreciate that schools deal with these things from day to day, and they can usually deal with them very practically and informally in a way that's satisfactory from the school's point of view and also from the parent's point of view. But the value of what I'm going to say about these things is that when all else fails and you get, as you periodically do, parents who are totally uncooperative and unreasonable, you can retreat to the formal legal position and say, well, that's the legal position. If we can't agree to some other informal arrangement, then that's the position that we're going to adopt as the school. So with the change of name of the student, the contract, don't forget, is between the school and the parents, not the student. The student is the object of the contract and the beneficiary of the services that are to be provided under the contract. As long as the child can be identified under the new name as the same person who was identified in the contract under the old name, there's no need for a new contract. I might just add that you will need to make sure that the records of the school are based on the birth name or the registered name of the child, because that flows through into governmental regulation reports and statistics and all that sort of thing. So you need to keep an eye on that. Sometimes the parents will say that they don't want the child to be known by their birth name. I mean, they might come in and say, I don't want Fred to be known as Fred, I want him to be known as Frida or something like that. And that's okay as long as it's not going to cause harm to anybody. But the records themselves must be based on the correct name.
Thanks, Robert. Question 2 deals with separated families from a fee perspective. I know as a business manager, this is one of the ones that probably hit my desk every week, and how to deal with that. So question 2, what would be your take on that?
Right, well, assume that both parents have signed the enrolment contract and then they divorce or separate and they want some other arrangement. Either one of them will be liable or none of them, whatever. The position is quite simple. They're jointly and severally liable under the contract until the contract's terminated. So either one of them can terminate the contract. It doesn't require both to agree to do that. So either one can terminate it, and it must be done obviously in accordance with the terms of the contract, which you will usually require one term's notice. So they're probably stuck with it for at least a term, but if they give the notice of termination properly, the contract will terminate, and it's then a matter between the school and whatever parent wishes to re-enrol the student to enter into a new enrolment contract.
And the question around managing the current fees and the responsibility for future fees, how does that sit with that contract then?
Well, both of them are liable for the current fees to the full amount, and the responsibility for the future fees will be a matter of negotiation over the new enrolment contract as to whether one of them or both of them are going to be liable for the fees in the future. It is possible to draft a contract, incidentally, which doesn't require the enrolling party to pay the fees. We have done that in a case where there was an agreement between the parents that one of them would be responsible for the fees and the other one was not going to be responsible. So you can have a separate contract for them, but they're both generally subscribed to the obligations under the contract, but just not the fees for one of them.
Question 3. I know you said a little earlier in your presentation that you had very carefully drafted the enrolment contract template that ISQ has available to its members. This is looking at adding a phrase into that contract around schools requiring parents to discuss any issues with the school first before they withdraw their child's enrolment.
Well, it'd be very useful for the parents to let the school know why they're withdrawing the child from the school, and it is possible to draft the enrolment contract so that in order to give a valid notice of termination of the contract, there is a precondition, which is that they have to state a reason for the termination. Of course, they can state any reason they like and they will have complied with that precondition, so the value of it might be questionable. There will also be circumstances where they would be embarrassed to tell you what the real reason was for the withdrawal of the student from the school. For example, they might have run out of money or something like that, and that's something that they would not want to disclose just for purely personal reasons. So I'm inclined to think in the context of trying to keep the enrolment contract simple and straightforward, it's probably best not to do that, but at the same time there's nothing to stop the school from asking them at the time that they terminate if there is any particular reason why they're doing so.
There are a couple of questions 4, 5 and 6, but we'll handle each one separately, but they're all around parental permissions, around particular aspects of school. The first one is around parental permission for excursions, camps and sporting events. Practically it's an issue for schools. How might they manage that well?
Yes, I give a lot of thought to this because it is something that is extremely time consuming throughout the whole school for obtaining these consents, because it necessarily involves a lot of follow-up to try to get parents who forget about it or can't be bothered or whatever it is, or who are away at the time, to give the consent. So I think, bear in mind that the consent is just a consent. What it does is it says, we have told you what this excursion is going to involve. We may have pointed out risks that will be involved in the excursion, and we would like you to tell us that you have read that and understood it, and that you consent to your child being sent on that excursion. It's not ever going to release the school from liability for negligence of the school in running the excursion. What it really does is allow the parents to give the school a warning or to highlight risks which may attend a particular student's attendance on the excursion. So if they're allergic to Vegemite or something like that, the parents may wish to know. So I think that the best way to deal with this is in the enrolment contract, the parents will consent to the child going on excursions. I think I put in the ISQ contract that if we were going to keep them out overnight, then we would require a consent for that particular excursion. And the reason for that is that the risks are enhanced once you get into situations of greater intimacy between the students and their supervisors. So for those things, the consent is required. The child, of course, can never consent in a manner which releases you from legal obligations, because they're never considered able to do so. But it's all part of the general circumstances surrounding an injury which may occur on camp. If the parents have been told exactly what's going to happen, if the parents knew something and didn't tell the school which would have avoided this thing happening, then that is particularly relevant. If the child is, say, in grade 12 and quite mature and doesn't tell you that they're allergic to Vegemite, then those are factors that are taken into account when the rapacious law firm comes knocking on the door with a claim for personal injury.
Question 5 is around that implied consent for school activities in your enrolment contract. Would you expand a little on what a school might do if they have an implied consent in their school activity enrolment form, what they might need to do to make sure that parents are aware of what the activity is as they move throughout the years? Because obviously these contracts might be signed at prep when the child is only 4 or 5, and as you've indicated, lasts through till they're 17 or 18. So what activities would a school need to do to ensure that this implied consent continues to be enforceable?
Well, it's actually an express consent, because the enrolment contract will require the parents to sign a document that says they consent to the child going or being involved in excursion activities as a normal part of the schooling process. And so what we're suggesting should happen is that they give that consent, and then for any particularly high risk excursions, like if you're going to skirmish with live ammunition or something like that, then you're probably going to need an actual consent from the parents before you do that. So you've got to be practical about these things, but by the same token, you don't want to put a noose around your neck so that you have to spend all of this time trying to get a written consent every time you take them out of the school grounds.
Thank you, that's really helpful. Question 6 has another type of consent around the use of photographs in school marketing campaigns, and it's one that we certainly get asked a lot about.
Yes, it's really quite problematic, this one. And it has a lot to do with privacy legislation. So I've seen the privacy manual that ISQ, or the Associations of Independent Schools, and the Catholic Education have developed, and it's really well prepared, if I might say so, very thoughtful, and it's based on practical experience as to what the schools can expect. So photographs are very personal information, and the circumstances surrounding the taking of the photographs, who takes the photographs, where the photographs are taken, how old the children are when the photographs are taken, and so on, are infinite in variety. So I don't want to give a bland overall expression about this, but if I had a child who was to be involved in a marketing campaign, I'd want to know about it and consent to it, I think. I mean, if your child's going to be on a billboard on Moggle Road for the next year or so, that's something that I think the parents will want to know about and will want to consent to. And don't forget the student. The student might have to consent too if they're of an age where you think that they're capable of understanding the implications of it.
Can I tease that out a little more? Can the student consent even if the parent doesn't consent?
Yes, it gets back to what's in the best interests of the student. And if there were circumstances where the school felt that it was in the best interest of the student to use the photograph and the student consents, then the school might well consider going against the wishes of the parents in that case. An example might be if the child attends a school formal, and photographs are normally taken at school formals, and often they're posted up on notice boards or on, I suppose, on the internet these days, websites and so on. If the child has no objection to that at all, then it may be a bit unreasonable for the parents to come in and say, well, no, we're not going to allow the child to do that. And there may be surrounding circumstances where refusing to let the child appear in a photograph might actually have adverse consequences for the child, who might be bullied or something as a result of it, who knows. But the circumstances are infinite and just require a lot of common sense and precaution, I think.
That's great. That's a really good example. Thank you for that. Now, I think question 7 you've probably already addressed, but let's just check and make sure that we've covered everything off. The legal age for a student who can enrol themselves, and then legally sign forms. Right,
so any child, which is a person under the age of 18 years, can't enter into a contract which is enforceable against the child unless it's a contract for necessities. That's the law in Queensland. There is a law in New South Wales legislation which is slightly different from that, but it's still not of much use. It's a situation which is not uncommon. I think you've told me, Judy, before.
We would certainly have students, particularly in some of our our special assistance schools, who might not have a legal guardian who would be signing for them. And so they might themselves at 16 or 17 be actually enrolling in the school as their own independent person.
Yes. Well, there are a few things that you can say about that. If fees is going to be an issue, that is, if it's not the subject of government funding of some kind entirely, and if it's necessary to obtain fees from somebody for the education of that child, then either you should get a third party to sign a contract under which they agree to pay the fees. It could be specifically just that they agree to pay the fees for the education without all the other information in the enrolment contract. Or you might consider getting the fees paid before the term commences in each case, in which case you're covered, obviously, for the fees that are going to be there. But they can't sign all of the other issues which are in the enrolment contract, some of which we've discussed today, communication, consent to excursions, all of that sort of thing. It's very doubtful whether any of that would be enforceable against the child. Discipline would be another one, where the child agrees to comply with the policies of the school and so on. It'd be very difficult to enforce any of that, but it wouldn't stop you holding it up in front of the kid if trouble arose and say that morally, if not legally, they'd committed to this and you expected them to observe it.
Question 8. A student from New South Wales attending a school in Queensland. Are there any particular issues around that?
Unless there's something in government grants, which I'm not aware of, but they are in fact fairly normal people south of the border, and we do accept them in schools up here.
Question 9. What documentation should a school obtain? And this is in an issue where a grandparent might be caring for a student but obviously isn't the natural parents of a student.
Yes, is this in the sense of family court documentation?
Where grandparents may be the ones who are actually enrolling the student. They're in some sort of care of the student at the point of time, but they're not the natural parents. What sort of documentation would a school expect?
Well, it's not necessary to obtain any documentation. Theoretically, you could get the man on the moon to enrol any student at all. But I think probably the broader issue of the duty of care that the school has means that they have to make some inquiry about a plausible explanation for this apparently unrelated person or distantly related person enrolling the student and not the parents enrolling the student. But I'd be inclined to think that if Granny comes in with a plausible explanation as to why she's enrolling the students, then I'd accept that at face value. But if there was anything which put the school on inquiry or made the school feel uncomfortable because the school's got terrific experience in all of these things and they can sense when there may be problems, at that point you might go further and insist on a satisfactory explanation as to why this child is being enrolled by a third party. Does that make sense, do you think?
I think so, yeah. In terms of information around students who might have particular disabilities, would the grandparents be expected to provide that information? Because we know that's part of the enrolment contract.
Certainly somebody's going to be responsible for doing it, and as the enrolment contract standard form is drafted at the moment, it's the people who sign the contract who are warranting that they've provided all that information. So if Granny signs the enrolment contract and is responsible for the fees, then she's going to be subject to that warranty as much as the natural parents would be if they had signed the enrolment contract. So somebody's going to have to sign the enrolment contract and warrant that that information has been provided.
Question 10 addresses this from a slightly different perspective, where the parents, the natural parents might be the enrolling party, the contracted party, but grandma, grandpa, is actually the person who's paying the fees. And what sort of information can be given to grandma or grandpa as the person who's paying the fees if they are not in fact the contracted party for the enrolment?
Okay, so if a third party is just paying the fees without having a legal obligation to do so under the enrolment contract, they're entitled to nothing.
That then begs the question, how do they know how much the fees are going to be? Is the school able to release that information to them if their agreement is that they will pay the fees? Because otherwise, how do they become aware that the fees are due and payable?
Well, the enrolling contracting parties should tell them how much the fees are, because the school will be chasing the people who signed the enrolment contract. It is possible, though, in terms of your question, that there's no communication between the parents and the grandmother. I mean, the practical position is you just give it to Granny and she'll cough up. Most of the time that's not going to cause any problem at all. I mean, it doesn't provide any information necessarily which is sensitive information about the child at the school, or most people aren't going to object to it, I wouldn't have thought. If somebody objects, we'll just say, well, we won't provide it anymore and we'll bankrupt the contracting parties or something like that, something nice.
The second part of this question is, if the grandparent is actually the person who's agreed to pay the fees, again, they're not the contracted party, is the school able to follow them up if payments are missed?
Well, the short answer is no, unless there's a contractual obligation agreed to by the third party to pay the fees, and if they just voluntarily pay the fees, there won't be an enforceable contract with them.
Is there anything in terms of the length of time that grandparents might pay fees if they've been paying the fees for the last 10 years and then they stop? Is there anything that becomes almost an implied contract in that payment?
Well, strictly speaking, no, but it would not be unusual for circumstances to develop where the natural parents get into, say, financial trouble and the grandparent comes in and says, well, I'll pay for the kids' schooling. The problem with finding an enforceable contract on that basis is consideration, which is a technical contract term. But if the situation was the school was actually saying to the parents, well, unless you pay the fees, this child is going to have to leave the school, the grandparent comes in and says, what if I pay the fees? Can the kids stay in the school? We say, yes, we will allow the child to remain in the school if you pay the fees which are due under the enrolment contract. In those circumstances, there can be a contractual relationship between the grandparent and the school, and it would be enforceable until the enrolment contract is terminated.
Should the school be getting that in writing?
Well, preferably yes. But for the reasons that I've explained, it will often be the case that the arrangement's unenforceable in contractual terms.
Question 11. In this age of the digital forms, digital policies and use of websites, schools have questions around how they make enrolling parents aware of their school policies and whether it's sufficient to point them to the website or whether they need to actually hand them the policies and ensure that they're aware of them.
There are some policies which are absolutely fundamental and really critical to the proper progress of the school. I saw an enrolment policy document recently from one of the schools which had set out in some detail the disability assessment process. So in terms of what I was saying previously about it being important to be informed about special requirements of a student before they enrol, it was very important and very useful for that enrolment policy to go out with the enrolment application form rather than the enrolment contract. So that's one example where it would be actually, from a legal point of view, it would be very important to get that to them before they are actually enrolled. Because the enrolment contract will say you have to comply with the policies of the school, we'll publish the policies of the school on the website, and that's fine, but that only applies after they've enrolled. So if you want them to do anything before they enrol, you need to tell them up front. And another area where you will need to give them policies is the area of privacy. So, you've got to tell them what you're going to use the information for and all the stuff that's come with the latest amendments to the privacy legislation, which is just extraordinary in detail. So you're required, in fact, to give them that information before they enter into the contract. So you will need to do that. And if there are any others, don't give them too much because they're obviously not going to read it. It'd be like the Commonwealth Bank website where the terms and conditions, if you want to open an account with the Commonwealth Bank, I looked at it 3 years ago, I think just to see what the terms and conditions actually would be. You know, I was the one person in Australia who'd actually not ticked the box and said I agree to the terms and conditions without reading them. So I read them. It was 57 pages on their website, interconnected with other terms and conditions which applied elsewhere. Now, that's just stupid. And frankly, nobody's going to read it. No court's going to say that somebody should have read it. So the effect of policies being on a website is limited to some extent. It's another reason why the enrolment contract should be kept as simple as possible, and another reason why the number of policies that, or policy documents or extraneous documents from the enrolment contract that you give to them should be limited in number and just focus on the things that are really important. I should also add that although the enrolment contract will say that they have to comply with the policies which are published on the website, you can't substantively change the terms of the enrolment contract by changing one of your policies on the website. Now that's important because if the contract is in a standard form which applies grades 1 to 12, usually they don't get changed formally between 1 and 12, and people might tend to rely on substantive changes being done through the website. Won't work if somebody wants to challenge it.
So tease that out a little further. If the school was looking at changing substantively some of their policies, they would need to go back and engage with a new contract or do a variation to the contract, or what's the way to notify parents when that happens?
Well, what I'm talking about as a substantive alteration is an alteration to the terms of the contract itself. So if the contract said you have to give a clear terms notice, you couldn't put up a policy on the website and say you have to give 3 terms notice and expect that there will be binding obligations on the parents coming from that. So where there's a conflict between anything in the contract itself of substance and the school policy, then the contract will prevail.
The second part of question 11 asks about parents signing off digitally on the contracts. Is that, in this age, it's quite common? Is that acceptable?
Yes, it is. There is legislation which deals with electronic transactions and specifically sets out circumstances where contracts can be entered into digitally, but there are real practical difficulties in actually complying with that legislation, not least is because the parties have to actually agree before they sign the contract that they're going to be bound by an electronic signature, which is practically very difficult to achieve. But having said that, the courts readily accept that there can be offer and acceptance and the formation of a contract, even where writing is required under the statute of frauds, through email correspondence. It introduces all sorts of lovely other interesting questions of technical kind, which lawyers really enjoy. But put most simply, yes, it can be, but the school needs to make sure that it keeps a proper record of these things. That is a complete, if somebody scans a document so often, they forget to scan every alternate page, or they chop the top or the bottom off, or whatever it is. So you need to be careful in that sense that the records are complete. And the other thing is, these days, every time you change your hardware or your software, you're liable to lose half of the information that's been provided before, but others would know more about that than I do.
Question 12. This is an interesting question that schools often come up against, where one parent wishes to take over and be the sole signatory and actually change the terms of the contract, and what schools need to do to notify a party who's being dropped off the contract, and whether they need to put a new one in place.
Well, neither of the parents as parties to the contract can vary the contract so as to delete the other parent as a party to the contract. What they would have to do is terminate the contract and then enter into a new contract with the school, which just has one of them as the party on it, if they can agree to that. But from the school's point of view, the school wants to act in the best interests of the child, so it really is put into a position where it needs to make sure that the child isn't disadvantaged by whatever the arrangements are going to be. And that would be part of the considerations surrounding the negotiation of the new enrolment contract. So it's not necessary for the school to get their consent at all, because either one of them can terminate the contract, and then it's just a matter of negotiating a new one.
Robert, getting both parents to sign the enrolment contract, I don't know if that's also another question that rings my phone quite consistently. How important is it for both parents to sign the enrolment contract?
Strictly from a commercial point of view, it's very important, because you've then got them nailed, you know. Debt collection becomes much easier if you've got both of them under the hammer rather than just one of them. So it's really a case of the more the merrier. Get the maternal and paternal grandparents to sign the enrolment contract as well. Get the people down the street to sign it too. They're all going to be liable contractually.
So I like that. The more the merrier, and then you can actually take everybody to court or to debt collection.
Or any one of them, which is even better. You just pick the best, the fattest one is the one, I mean, fattest in terms of money is the one that you go for.
Question 14 talks about parenting agreements, and it's an area that schools find particularly difficult to manage. Are they required to cite parenting agreements? Should they be allowed to? Should they be holding them on their files? You said earlier that parenting agreements rarely ever bind a school, so are they actually even of interest to schools?
Well, yeah, you know, it comes up all the time, doesn't it? And you will have noticed that. I wouldn't be bothered with it myself unless circumstances arose, as they can and commonly do, where the school had some concern about, say, who was picking a child up from school. You know, I'm talking about a situation where the school had actual suspicions of improper conduct by somebody who was collecting the child from the school. It would then be reasonable for the school to ask a parent informally, what's the deal? Is this okay? Is everything all right? You know, that sort of informal query. But there's not really much point in getting parenting agreements except to resolve a difference which needs to be resolved. Somebody could produce a parenting agreement as evidence to support whatever they're saying. But the problem with them is that a parenting agreement can be altered by the court. You wouldn't necessarily know that the copy of the agreement that you have is either complete or current. So, you know, you run into that sort of problem if you try to do it. But certainly as a matter of course, I wouldn't be bothered with it.
Okay, that's good advice. Our last question relates to schools receiving letters from lawyers or claims from lawyers in particular requesting information from the school about a current student. What sort of information is the school required to give? If the letter asks for everything including what they had for breakfast, is the school required to give that information? What level of information? Do they actually have to comply with these requests?
Yeah, it's one of those tricky situations that schools can get into. So it's got a number of aspects to it. The first one is that if the letter from the lawyer says he's acting for a parent, you may accept that as the truth, because if a lawyer wrote a letter saying he was acting for somebody when he wasn't, or she wasn't, that would be serious professional misconduct. So you can accept the word of a lawyer. And if you run into trouble by doing that, you can complain to the Professional Standards Unit, who will take disciplinary action against them. So that gets rid of that bit. Now, the thing about the documents that have to be produced relating to a current student, if it's for a natural parent, if the natural parent makes the request, then they're entitled to do so on two levels. One is a level which requires the school to report to the natural parents, so you have to keep them informed about the academic progress, any problems, etc. with the child in the school. You have to do that, as we've seen, both under legislation and in accordance with the contract. You don't have to produce to them documents which are internal documents within the school. So the memo from the deputy to the principal that outlines disciplinary problems and how the school should deal with them in relation to this child doesn't have to be disclosed normally. The second area where disclosure is required is where there's a court order. Now, the court can order any document to be disclosed, but there are some documents which don't have to be disclosed, and they are mainly documents which are not relevant to whatever the action is under which the subpoena has been produced. And the second area is legal professional privilege. So if the school has correspondence with the school's lawyers about something, then that documentation doesn't have to be produced. Now, the third area where the documentation has to be produced these days is under the privacy legislation, because any personal information which identifies the student is susceptible to a request from the student or on behalf of the student, which comes from the parents during their minority. And you have to produce all of the information that you have, which is personal information as defined in the Act, unless it comes within one of the numerous exceptions to that particular obligation. In looking at that privacy legislation, it is an absolute nightmare. I mean, the amount of time that schools would have to spend going through all the documentation, finding all the documentation which related to a particular student, it's just awful, I think. Anyway, I'm not supposed to say things like that, I suppose, but honestly, if you get a request under the privacy legislation, you really need to refer it to somebody within the school who you're supposed to have a special privacy commissioner, commissar within the school who's going to deal with all of this stuff, and they will have a better idea, perhaps through the manual that we referred to previously, as to what exactly is going to happen. But I'd be very reluctant to give anybody any advice about a response to a privacy information request without looking at the privacy principles very carefully first to make sure that it was all covered. So I think that answers that question, which is actually a question on about 4 different levels.
As a follow-on from that, I often am asked by schools, can they charge for the time and the effort and the photocopying and things that it takes to comply with this? Is that acceptable?
What, the privacy? Well, under subpoena, you can request payment of reasonable expenses which are incurred, and that may include taking the documents to court. You see, the other thing you can do there is you can actually tell the other side to the court action that you've received a subpoena. That then enables the other side to go to the court and ask for the subpoena to be withdrawn for whatever reason they want to give. And you can get expenses for attending court. I think you can also get reasonable expenses under the privacy legislation because the documentation can be quite voluminous. I'm not sure that you can charge for your time in doing it though.
So am I hearing you say that if a school receives a letter from a lawyer, if they then make sure the other parent is aware of it, that they should probably not process that within the next 24 or 48 hours? There's obviously a period of time you're allowed to process that before you're not deemed to be not complying with that request?
If it's a subpoena, it will say that it has to be produced to the court, not to the parent, but to the court, but at a certain time. And of course, so you must comply with that or ask for an extension if that's warranted in the circumstances. But generally, do allow a little bit of time and notify the other side as to what's going on so that they can have a brawl if they want to.
Great. Thank you, Robert. Do you have any words of wisdom or finally summarising up before we finish?
Yeah, look, I think the enrolment contract is something that's grossly underestimated in importance for the schools. It's likely to become more important in the future than it has been in the past. It's something that the schools shouldn't fiddle around with without some sort of expert knowledge about what they're doing, because some of the contracts that I've seen, which include various provisions which, while well-intentioned, completely miss the mark of what they intend to do and create all sorts of problems if somebody were minded to take it up, means that they should be very careful with them. And the other reason they should be careful with them is because it's a standard form. So if you've got 1,200 kids in the school, you've probably got 1,200 enrolment contracts out there. And if there's something major wrong with your enrolment contract, you're going to have 1,200 of them that are majorly wrong. So that also emphasises the importance of making sure that they're properly done. ISQ, as always, has a model contract which will serve your purposes very well.
Thank you, Robert, for an excellent presentation today. We have very much appreciated your insights and your expertise. Given the level of interest in this topic, we know that it is at times a contentious issue for schools, and I know that what you have presented today has assisted schools in getting it right. Thank you to those who have registered to participate in this webinar. Before you close the webinar link, would you please take a moment to complete the feedback survey to assist us in ensuring that we provide relevant professional development. Once again, thank you, Robert. Have a great day.